Supreme Court in a 6-3 decision ruled that former President Donald Trump and other presidents have absolute immunity from prosecution for official acts taken during their presidency. However, the justices ruled presidents can still be charged for acts that weren't part of their official duties. The landmark case on presidential powers is the first of its kind, as never before had the Supreme Court considered if a president could face criminal charges for actions taken while in the Oval Office.
Okay, folks. Sit down for this one, because what I'm about to walk you through is one of the most documented and closely watched civil litigation matters involving any American president in modern history. The E. Jean Carroll cases have resulted in combined jury verdicts totaling approximately $88.3 million against Donald Trump. These consist of 2 separate trials and 2 distinct verdicts. In May 2023, a jury found Trump liable for sexual abuse and defamation, awarding roughly $5 million in damages. Then in January 2024, a second jury addressed additional defamation claims stemming from Trump's continued public statements about Carroll after the first trial, awarding approximately $83.3 million. Adding those together brings the total judgment to $88.3 million. This represents one of the largest civil judgments ever entered against a major American political figure in recent decades. Trump appealed the verdicts to the United States Court of Appeals for the Second Circuit, which affirmed the lower court's decisions. Following that affirmation, Trump petitioned the Supreme Court for a writ of certiorari, asking the nation's highest court to review the case. His petition argues that the trial court's handling of certain evidence violated key provisions of the federal rules of evidence, specifically Rules 413, 415, and 404B. The petition also frames the proceedings using language that describes what it calls the mistreatment of a president, suggesting that Trump's unique political status should influence how the civil claims were evaluated and decided. Supporting Trump's position, America First Legal, an organization founded by and still connected to Stephen Miller, filed an amicus brief on December 11, 2025. That brief echoed the mistreatment framing and urged the Supreme Court to grant review. In response, E. Jean Carroll's attorney, Roberta Kaplan, submitted an opposition brief on January 14, 2026. Kaplan argued that the petition does not present any compelling federal question that warrants Supreme Court intervention, and that the trial court's evidence rulings fell well within proper judicial discretion. As things currently stand, Trump has posted a $91.63 million bond that sits in escrow pending the Supreme Court's final decision on whether to hear the case. The matter has been distributed and redistributed for conference consideration multiple times since February 20, 2026. This repeated redistribution suggests the petition has received serious attention from the justices, even if they ultimately decide against granting review. The entire situation forms one of the most significant pending civil litigation matters currently affecting any sitting American president, carrying both substantial financial implications and broader questions about how the legal system treats high-profile political figures. Before we dive deeper, let's be honest about something important. Trust in mainstream media has eroded significantly in recent years, which is exactly why platforms like Pump Politics exist. We focus on delivering real stories with real context and without the usual corporate spin or partisan filter. If you want to stay informed without the noise, join our free daily newsletter. We send the most important updates straight to your inbox every single day. Just click the link in the description to subscribe. And if you believe in supporting independent voices that prioritize truth over narrative, consider joining our community. Your support helps us keep doing this work. All right, now let's get back to the full picture and walk through the background of the E. Jean Carroll cases in detail. E. Jean Carroll is a longtime journalist and author who first publicly accused Donald Trump of sexually assaulting her in the mid-1990s. She claimed the incident occurred inside a dressing room at Bergdorf Goodman, a luxury department store in Manhattan. Trump has consistently and vehemently denied the allegations, calling them false and politically motivated. In response to his public denials and additional statements he made about her, Carroll brought civil lawsuits that included both sexual abuse claims under New York law and separate defamation claims. These cases moved slowly through the New York court system over several years before reaching trial. The first trial, held in May 2023, resulted in a jury verdict finding Trump liable for sexual abuse rather than the more serious charge of rape under the applicable New York statute at the time, along with liability for defamation. The jury awarded Carroll approximately $5 million in total damages. The second trial, which took place in January 2024, focused exclusively on additional defamation claims. It centered on statements Trump continued to make about Carroll, even after the first verdict. That jury returned a much larger award of roughly $83.3 million, bringing the combined judgments to $88.3 million. These outcomes stand as among the most substantial civil liabilities imposed on any prominent American politician in modern times. A key piece of evidence that played a significant role during the proceedings came from Trump's own deposition testimony taken before the trials.
In that sworn deposition, Trump was shown a photograph and appeared to confuse E. Jean Carroll with his second wife, Marla Maples. This moment became particularly notable because Trump had previously stated publicly that Carroll was not my type. The apparent mix-up in identifying the woman in the photo undermined that particular line of defense in the eyes of the jury. Additionally, the deposition and broader discovery process brought forward other historical statements and patterns of behavior that the jury was allowed to consider when assessing credibility and the overall factual record. One especially interesting element involved Trump's 1990 sworn court testimony in an unrelated matter, where he admitted to using the pseudonym John Miller to contact reporters and praise himself.
While not directly part of the Carroll allegations, this and other documented sworn statements over the years contributed to the broader evidentiary context that helped shape how the jury evaluated Trump's credibility on specific factual disputes. The accumulation of these materials created a detailed paper trail that both sides used to argue their positions during trial. Turning to the financial side, after the January 2024 verdict, Trump was required to post a bond of $91.63 million to stay enforcement of the judgment while appeals proceeded. That bond remains in escrow today as the Supreme Court considers whether to grant certiorari. If the court ultimately denies review, the bond will be released to Jean Carroll, allowing her to collect on the judgment. If the court grants review and takes the case, the bond stays in place while further litigation continues. Either outcome leaves that substantial sum of money temporarily unavailable for other uses. Posting such a large bond is standard procedure in civil appeals to protect the winning party's ability to collect if the appeal fails. The amount typically includes the judgment plus interest and potential additional costs. For Trump, this $91.63 million commitment, combined with other ongoing legal financial obligations, represents a meaningful constraint on available capital. Now let's examine the amicus brief filed by America First Legal. On December 11, 2025, the organization submitted a friend of the court brief supporting Trump's petition for certiorari. America First Legal was founded by Stephen Miller, who currently serves as Deputy Chief of Staff for Policy in Trump's second term. The brief used strong language framing the case as an example of the mistreatment of a president. It argued that the way the trial court handled evidence and the overall proceedings reflected unfair treatment tied to Trump's political position. The filing highlighted how Miller's ongoing ties to the organization create an interesting structural dynamic, with an outside group providing coordinated legal support to the sitting president's personal litigation interests. This type of amicus support is common in high-profile cases, but the specific framing here raised broader questions about whether civil litigation should treat presidents differently from ordinary citizens. In direct response, Roberta Kaplan, Carroll's lead attorney, filed her opposition brief on January 14, 2020. Kaplan contended that Trump's petition failed to identify any compelling federal question worthy of Supreme Court attention. She defended the trial court's evidentiary rulings as proper exercises of judicial discretion, and argued that the mistreatment of a president framing did not present a legitimate constitutional issue. Kaplan emphasized that civil cases should be decided on their substantive merits regardless of the defendant's political status or fame. Her brief portrayed the litigation as a straightforward application of established legal rules rather than any kind of extraordinary political persecution. The Supreme Court's handling of the petition has followed an interesting procedural path. Since February 20, 2026, the case has been distributed and redistributed for conference consideration multiple times. In Supreme Court practice, repeated redistribution often indicates that the petition has caught the interest of one or more justices and is receiving more careful internal discussion than the average case. While this does not guarantee that certiorari will be granted, it does show the matter is being taken seriously at the highest level.
The eventual decision could play out in several ways. Outright denial would allow the bond to transfer to Carroll relatively soon. Granting review would extend the timeline significantly and open the door for full briefing and oral arguments, or the court could issue narrower procedural orders affecting specific aspects of the case. It is also worth considering how the landmark Trump v. United States immunity decision from July 1, 2024, interacts with the Carroll litigation. That ruling primarily addressed immunity from federal criminal prosecution for official acts. It did not directly impact state-level criminal cases or private civil litigation like the Carroll matters. As a result, civil accountability mechanisms have continued to function independently of the immunity protections established for federal criminal contexts.
The Carroll cases serve as a clear example of how civil lawsuits can still impose significant financial and reputational consequences even when criminal avenues face constitutional hurdles. The $91.63 million bond exposure demonstrates financial accountability operating through traditional civil channels rather than criminal ones. This parallel system helps address potential accountability gaps that some observers, including Justice Sonia Sotomayor in her dissenting opinion in the immunity case, warned could emerge if immunity were interpreted too broadly. Civil and state-level tools continue filling those gaps where federal criminal mechanisms are limited. To fully understand the scope of this Supreme Court petition, it helps to break it down into its core documented elements. First, there are the original jury verdicts themselves, totaling $88.3 million across 2 trials. Second, the mechanics and current status of the $91.63 million appeal bond. Third, the amicus brief from America First Legal and its mistreatment of a president framing. Fourth, Roberta Kaplan's opposition brief pushing back against the need for Supreme Court intervention. Fifth, the ongoing pattern of conference distributions and redistributions since February 2026. These 5 converging threads paint a picture of a high-stakes civil matter with real financial stakes and important legal precedent implications, no matter how the Supreme Court ultimately rules. At the heart of Trump's petition are arguments concerning the federal rules of evidence, specifically Rules 413 and 415, govern the admissibility of evidence regarding similar acts or crimes in sexual assault cases, both criminal and civil. Rule 404b addresses the use of prior bad acts evidence for purposes other than proving character. Trump's legal team contends that the trial court improperly allowed testimony and evidence about other alleged incidents involving Trump, and that this material prejudiced the jury. The Manhattan trial judge had ruled the evidence admissible under these rules, and the Second Circuit agreed. The petition asked the Supreme Court to clarify the proper boundaries for admitting such evidence in high-profile civil cases. These are legitimate evidentiary questions that federal courts grapple with regularly, though whether they rise to the level of nationwide importance required for certiorari remains the central dispute between the parties. The size of the combined $88.3 million verdict is itself noteworthy. The $5 million award from the first trial covered both the sexual abuse finding and the initial defamation claims. The much larger $83.3 million award in the second trial reflected the jury's view that Trump's repeated public statements after the first verdict had caused additional, compounding harm to Carroll's reputation and emotional well-being. That second award included significant punitive damages intended to discourage similar conduct in the future. Juries have broad discretion in setting damage amounts when they find liability, especially in defamation cases where reputational harm can be difficult to quantify precisely. The overall judgment stands out as one of the most substantial ever levied against a political figure through civil litigation in the United States. Broader context around Trump's approach to legal challenges adds another layer. For instance, White House Chief of Staff Susie Wiles reportedly told Vanity Fair that the prosecution brought by New York Attorney General Letitia James represented one retribution in Trump's view. Such comments have fueled discussions about whether personal grievances influence how Trump and his team respond to legal pressure. Throughout the Carroll litigation, Trump has maintained an aggressive public posture, often launching counterattacks against Carroll and her attorneys. This pattern of strong public rhetoric during and after civil proceedings is not unique to this case but has become a recurring feature of his legal battles. Plaintiffs facing Trump in court frequently encounter not only legal defense but also intense public scrutiny and criticism from his supporters and media allies. This dynamic can make civil litigation against high-profile defendants more complex than standard cases. The Carroll bond exposure does not exist in isolation. It operates alongside several other major legal and financial pressures. In the separate New York civil fraud case brought by Letitia James, Judge Arthur Engoron issued a judgment of approximately $464 million, with accruing post-judgment interest pushing the total liability close to $700 million by April 2026. Trump was able to post a reduced bond of $175 million in that matter, after arguing he could not secure financing for the full amount. When you combine the Carroll $91.63 million bond with the Engoron $175 million bond, the total encumbered capital becomes substantial. Add to that the 34 felony count criminal conviction in New York, which remains under appeal, and the picture becomes one of unprecedented multi-front legal and financial exposure for any modern president. Further compounding the situation has been the significant decline in the value of Trump Media and Technology Group stock. Independent reporting from outlets like Forbes has documented that the sharp drop in the company's share price has reduced Trump's estimated net worth by more than $1 billion. This market-driven loss, paired with the large appeal bonds tied up in escrow, creates real liquidity and capital constraints. Banks and financial institutions have also shown increased caution in dealings with Trump-related entities. Some have called in existing loans while others have declined to extend new credit or have tightened insurance terms. The combination of court judgments, reputational risks, and shifting market perceptions has made the traditional leverage-heavy business model Trump built over decades more difficult to maintain. What was once an empire built on aggressive borrowing and high valuations now faces simultaneous pressure from legal, financial, and market forces. From a larger perspective, the Carroll case illustrates how civil accountability mechanisms continue to function even when presidential immunity limits certain criminal avenues. The July 2024 immunity ruling focused narrowly on federal criminal prosecutions for official acts. It left state criminal cases and all forms of civil litigation largely untouched. As a result, private plaintiffs like Jean Carroll can still pursue claims through standard civil processes, and juries can still render substantial verdicts when they find the evidence supports liability. This civil track provides an important complement to other accountability tools. It ensures that powerful individuals remain subject to consequences in cases where the harm is personal rather than purely official in nature. Justice Sotomayor's dissenting opinion in the immunity case specifically highlighted the risk of creating a king-above-the-law scenario if immunity were too expansive. The continued operation of civil and state mechanisms helps mitigate those concerns by keeping alternative avenues of redress open. The cumulative legal pressure on Trump across multiple matters is difficult to overstate. He faces the New York criminal conviction with 34 felony counts still on appeal, the massive Engoron civil fraud judgment with its $175 million bond, the Carroll $88.3 million verdicts with their $91.63 million bond, and various other contempt and procedural rulings that have arisen along the way. Each of these matters demands significant time, attention, and financial resources. Time spent managing legal teams and court appearances cannot be devoted to political activities or policy work. Financial resources tied up in bonds cannot be used for campaign efforts, business expansion, or personal needs. The combined effect creates structural constraints that influence both personal finances and political maneuvering in ways few previous presidents have experienced. To be completely fair, defenders of Trump raise several legitimate counter-arguments that deserve consideration. They contend that the damage awards, particularly the $83.3 million defamation verdict, appear disproportionately large and raise questions about proportionality in civil litigation. They argue that the evidentiary issues involving Rules 413, 415, and 404B involve important questions of federal law that merit Supreme Court clarification, especially in politically charged cases. Some point out that civil lawsuits against prominent political figures inevitably carry political undertones that can influence public perception and even jury pools. Others suggest the overall pattern of civil and criminal cases against Trump reflects unprecedented targeting by political opponents rather than purely neutral application of the law. These points touch on real concerns about fairness, damage amounts, evidentiary standards, and the role of politics in the justice system. However, several facts make it difficult to dismiss the Carroll verdicts entirely as politically driven outcomes. Both trials involved extensive presentation of evidence and witness testimony over multiple days. The juries drawn from the New York community deliberated and reached unanimous verdicts on liability and damages. Trump's own deposition testimony, including the moment he appeared to confuse Carroll with Marla Maples, became part of the record and was weighed by the fact finders. The Second Circuit Court of Appeals conducted a thorough review and upheld the results. The bond requirement follows standard appellate procedure rather than any special rule invented for this case. Amicus briefs and opposition briefs were filed according to normal Supreme Court practice. The documentary record across years of litigation reflects a civil process operating through established legal channels, even if the parties disagree strongly on the merits.